Item number 1.
May we please, Your Lordship? Your Lordship, in fact, the brief was taken away from me. Now, again, they have re-engaged. Power has been filed again. Because I was unwell for 3 weeks.
Okay. Can this matter be taken up by this bench?
What? Yeah, no, Lordship. I think so. Lordship was part of this matter earlier.
Probably you were also there.
Lordship, you was Lordship.
Okay, so we'll pass on the orders. List this matter before any bench without B. What's charging? Justice. But it has to be very specific.
Item number 2.
But this was released by you earlier. No, you said you were disengaged, then re-engaged.
Again, re-engaged me.
Okay. That has gone on.
Power is there. File.
No. Has it gone on record? That
No, that has not gone on record.
then matter remains the same. Then
No. Ukalnama has been filed. Again, refiled by.
somebody else appeared after you left.
No, Lordship.
No.
No one was re-engaged. No one was
notice,
engaged.
issued.
Again, they came back to us.
Oh, even then, see,
No,
what I'm
power-
trying to say is,
Power again filed.
if your power is already there initially, then there's no question of filing fresh power.
Since it was taken away as an abandoned precaution.
Except if there is a clear noting that you have released the brief, and matter was handled by some other counsel.
But power already we have given. It's okay.
Anyway, it doesn't matter.
Much more.
Item number 2.
Number 3. Number 3, the another note.
What if it? Oh, 6 also. Lydia. That channel. So we'll fix this matter. 2 weeks.
Yes, Your Lordship. Can we let it be 3 weeks, my lord?
You've already filed your written argument,
No, Your Lordship. Only our argument had been concluded, Your Lordship.
and you have not started.
We have not started, and we'll also file the written argument, Lordship. So kindly give us 3 weeks, Lordship.
On payment with parties, this is matter of the 3 weeks.
Much obliged, Lordship.
Item number 6.
On payment, I will consume 2 weeks.
Item number 7.
Have you started? Yeah.
No, my lord.
Not yet.
Not yet.
3 weeks. 3 weeks. Huh?
Item
12.
number 12.
12 also, my lord.
Same.
Same.
Same. Huh? 12.
And 14 also same, my lord.
14. Same.
Same.
Should note it over. 12, 14. Anything else, Mr. Ashala?
My lord, I have this item number 20 here. We are yet to file paperbook, my lord.
Not yet. Fine.
No. Because we received certified copy only yesterday, my lord.
Ready to be called up.
Yes.
Item 13.
Who's for the appellant?
Miss S. now said, Your Lordship.
Where is she?
I have not seen her, Your Lordship.
The last time, I mean, the last order passed was 27/8. What happened?
Any mention?
Well, please, Your Lordship. Your Lordship, I beg to mention item number 10. Your Lordship, may this matter come after 2 weeks.
Just a moment.
Your Lordship, I'm appearing on behalf of the petitioner, Your Lordship. Objection, Your Lordship.
You're for?
Respondent 1 to 4, Your Lordship.
On premise by Mr. Legal Counsel for the respondent number 1 to 4 seeking accommodation. The same not objected to by Mr. Legal Counsel to the petitioner. Matters adjourned. This is same after 2 weeks.
Apply, Your Lordship.
If it may please Your Lordship, I would like to mention item number 13. Actually, I tender a sincere apology, but we have not been able to file the legible copy of the FIR on behalf of the appellant because
The paper book, my lord. There were some, my lord.
discrepancies.
So you correct it. 13.
Item number 13.
2 weeks.
3 weeks time may be granted, my lord.
Only for
Because the conducting counsel's father is very ill. He is 85 years old. So,
on premise by Mr. Legal Counsel for the appellant. This is matter up to 3 weeks.
Repair.
deeply obliged.
My lord, item 8, my lord, it's a joint request, my lord. From the respondent side, Mr. Shulai, senior counsel, is just out of bereavement, has just been back. So we have spoken. So somewhere next week or the week after, my lord.
2 weeks.
2 weeks, my lord.
On premise by the parties. This is matter up to 2 weeks.
Oblige.
Supplementary list, item number 1.
This is a teaser matter, Lordship.
Yes. So these are a batch of matters.
Yes, Lordship.
But the issue, of course, are different.
More or less, yes, Lordship. Because item number 1 and 2, termination without approval. Then item number 3 and 4, Lordship, they were terminated and the termination order has been set aside by the Director, Lordship. And item number 5, that is also termination. And in 1 to 5, somebody has replaced the petitioner, Lordship. Now, so far as the issue of termination is concerned, Lordship, the law is very clear. I have relied certain judgment that termination without obtaining approval from the government is illegal. Apart from the legality and illegality of the proceeding that were conducted against the petitioners, leaving aside the procedural irregularities in the DP proceeding, Lordship, the very fact the school authority did not obtain approval before terminating the petitioner. The law is very clear. I have cited some relevant judgment, Lordship. Now, Lordship, rightly or wrongly, somebody has been replaced. Petitioner has been replaced by someone, Lordship, the private respondent herein. Now, I have to tackle that issue. So, the teachers were subsequently implemented, Lordship. Now, my Lord will come to the affidavit filed by the respondent number 6, the concerned teacher, Lordship. Because my Lord have first one judgment that similar issue that matter pertains to an appointment without having B.Ed. Because the NCT norms stipulate that B.Ed is a mandatory and it should be obtained on the day of his appointment. But in that case, on the very day of appointment, that B.Ed was not there. That candidate was not qualified. So appointment was given. The government has given in time that he or she should complete within a period of certain year, 3 or 4 years. My Lord has quashed the appointment. Since there is a mandatory violation of NCT norms, so even subsequent obtaining of B.Ed will not cure the defects. So here also all the appointees, Lordship, without B.Ed. And I'll rely my Lordship judgment. Now whether the appointment was as per law or not, that is altogether different chapter, Lordship. No advertisement, no selection process, but that apart, the candidates were not qualified. And I am relying certain judgment, Lordship. Now, in fact, they are not the necessary party, Lordship. The judgment says they are not the necessary parties because they were appointed under different circumstances, Lordship. Because of the termination of the petitioners and the vacancy arose, and that vacancy they were accommodated. Now the petitioner here against the order of termination, if my Lord find that the very termination order is illegal, then if my Lord was that termination order, that their appointment will automatically go, Lordship. That is the judgment says, because they have come under different circumstances. So I'll just rely their affidavit and their appointment, Lordship. That is the respondent number 6, Lordship. My Lord will find the affidavit of the respondent number 6. In item number 2, Lordship. 1 and 2 is.
This is in item 2.
Item 2, Lordship.
Not in 1.
1 also, Lordship.
No,
It's the same, Lord. So one also
you will
can
decide. You decide to press item 1 or 2.
My Lord, one also no problem. Same issue, Lordship.
So we'll go with 1.
One.
468.
468, yes, Lordship. Government also
Affidavit dated
the date will be, Lordship, May 2025, man. May 2025.
yes 16/5.
Yes, Lordship. My Lord, here the petitioner will come to page 15, Lordship. The appointment order, Lordship.
Page 15 of this.
Affidavit in opposition, Lordship.
Annexure.
Annexure 1, Lordship, R1.
Yes.
The date of appointment is very important, Lordship. We will find the top, Lordship, 23rd April 2018. And the petitioner here, Lordship,
Yes.
suspended on 11/4/2018. First suspended, then terminated on 21st/9/2018. Immediately after the suspension, petitioner was suspended 11/4/2018, and immediately after the suspension, the petitioner was replaced by the respondent number 6. If may I read, Lordship, the appointment order, Lordship.
Yeah.
As per the decision of the Managing Committee of Garudubi Higher Secondary School meeting resolution number so and so, on the very day of suspension, Lordship,
Yes.
11/4/2020, which is duly approved by the District School Education Officer so and so, by the District School Education Officer, my Lord will find problem. Resolution was taken on 11/4 and the approval was taken on 19/4 and the appointment was given on 23rd/4. I am pleased to appoint Sri so-and-so past BA as a substitute assistant teacher of so-and-so against the suspension vacancy of Sri so-and-so. Petitioner. Now, Lordship, he is without.
See this order. See, it's a stopgap arrangement.
Yes, Lordship.
So nothing permanency is attached to it.
Yes, Lordship. That's why I'll come, Lordship. Now, on the next page, Lordship will find they have shown some advertisement. My Lord, that advertisement also pertains to non-sanctioned post, Lordship. That advertisement without any approval of the government. Now, my Lord will see page 16.
Just a moment. You have been suspended on 11/4.
No. Yes, Lordship.
Okay, 11/4.
11/4.
Now, this advertisement was floated on 21st March. So, how will that affect you?
11/4. Yes, Lordship. That is why because they are saying that my Lord, if my Lord will see the condition of the advertisement, my Lord will understand that under what circumstances these people have been appointed. Now they are saying that they have replaced me. Subsequently, their appointment has been regularized. Initial appointment was a stopgap. Then advertisement was before my suspension. Then the advertisement was for different post.
Yes.
Now they were accommodated. Now subsequently they are saying that these people have been appointed
in your place.
in my place.
Where is that?
Lordship, I'll come first. My lord will see the
So,
advertisement.
okay, let us be clear. Firstly, okay, let's forget about this stopgap arrangement.
Yes.
Now come to this advertisement, 21st March.
Yes, Lordship.
Pursuant to this advertisement and the selection process,
Yes.
Respondent 6 was appointed.
Appointed.
Okay.
Yes.
Now she was appointed in whatever.
Yes.
Whatever capacity, that's all. Now you said that subsequently this should have been a separate post.
Yes, Lordship.
Distinct from your.
My lord. My lord.
But where is the.
My lord, if my lord will see the advertisement, Lordship. The advertisement is altogether for different post.
Yes.
I'll come. I'll just read, my lord, the advertisement. Applications are invited in plain paper or prescribed in standard form of so-and-so Gazette Meghalaya from the citizen of India for filling up the following post of additional assistant lecturer, additional science teachers, and additional assistant lecturers, teachers in non-sanctioned post of Garudubi Higher Secondary post under the management of the managing committee of the school as shown below. My qualification is given MA, B.Ed, BA, B.Ed, BSc, B.Ed. So far as the qualification of the advertisement is concerned, that is, I have not dispute. They have given. Now, Lordship will find serial number 10 of the 6 of the condition, Lordship.
Yes.
The teachers, the appointed additional lecturer, additional science teachers, additional assistant teacher in non-sanctioned post may convert, adjust, upgrade into sanctioned post if vacancy will cause in future without further advertisement and interview subject to the selection of the managing committee and subsequent approval of the. Well, this is very, because this is just an IOS, Lordship. Now they have already, managing committee is already determined that these people are not going to be the teacher in my school. So I will put someone so that in order to avoid the selection process in a fair and transparent manner, they have accommodated in the future vacancy. This advertisement I am leaving aside that whether, because the advertisement has to be published in the newspaper, my lord is well aware, then department and selection process, board member has to be there, representative from the government. Managing committee cannot appoint since it is an aided school, Lordship. Grant is getting from the government. Now Lordship will see the appointment, Lordship. That is at page 36, Lordship. They have annexed so many documents. I am not going all those documents, Lordship. Page 36, Lordship. Date is very important, Lordship.
Yes. This is date of, order of appointment.
Yes, Lordship. 24/9/2018.
Yes. (24/9) or 24/7?
24/9, Lordship.
Or 24/9?
24/9. Below is that September is written, Lordship.
Yes, yes.
May I read, Lordship, the appointment order?
Yes.
In pursuance of the managing committee resolution number so and so dated 23rd September 2018 and subject to the approval of the district school education officer, a substitute assistant teacher of so-and-so. Earlier he was the substitute teacher for step gap arrangement, Lordship. Of so-and-so is hereby replaced as assistant teacher in place of Sri Mokbul Hossain, who is dismissed from his service with fixed monthly salary of so-and-so. Only per month, subject to B.Ed degree within 5 years from the date of the issue of this appointment. Failing of completion of B.Ed degree within the stipulated period, his service shall automatically be cancelled. The earlier appointment issued to him as substitute teacher by so-and-so is termed superseded, Lordship. My Lord, I was suspended on 11 March 2018. On the very day, this gentleman was appointed because resolution was adopted for her appointment. Then subsequently he was appointed. Then a namesake advertisement was floated for the non-sanctioned post. Then subsequently, Lordship, I was terminated. My termination is 21st September 2018. Immediately on my termination, now this gentleman was appointed in my place.
Where is your termination?
My Lord, termination in my writ petition, that I have already argued that it was without any approval. Now, leaving aside, Lordship, process has not followed. Now, once my termination, my Lord found that it was illegal and it is set aside, then this also will automatically go, Lordship. My Lord, I have filed my rejoinder to this affidavit, Lordship. I have enclosed the notification of NCT, Lordship. My rejoinder will be, it was filed on June, Lordship, in response to this affidavit, Lordship. My Lord has got it?
Yes.
There is only one annexure. Page 5 is the notification, Lordship. This is the statutory notification, Lordship.
Yes. Yes.
Page 6 will be the table, Lordship.
5 is the notification.
Yes, Lordship. The notification dated 12 November 2014.
Yes.
My Lord, will find column 4, Lordship. Page 6.
Yes.
Bottom.
4.
My Lord.
6.
Page 6.
First schedule.
Yes, Lordship, yes. Bottom.
Yeah.
Secondary / high school from 9 to 10.
Yes.
Now, the qualification will be, Lordship, graduate, postgraduate from so-and-so, I am not on. My Lord.
Yes.
And Bachelor of Education, B.Ed from so-and-so, A. The left side, the right side of the table, Lordship. Now again, B, Lordship, graduate or postgraduate from recognized university with at least 45 marks in either graduation or post-graduation, and Bachelor of Education from National Council for Teachers is recognized institution in accordance with the national so-and-so. C, Lordship, or 4 years degree of BA, B.Ed, BSc, B.Ed from any, because B.Ed is compulsory for secondary section, Lordship. Now, column 5, Lordship, senior secondary intermediate for classes 11, 12. Here also postgraduate would be at Lordship.
But you are not concerned with this.
My Lord, the second item is, that is why, since item number 1 and 2, item number 1, the petitioner in that secondary section, and petitioner in item number 2 in higher secondary section. So that is why I am referring, Lordship. Because for secondary, BA, BHC, BA. And for higher secondary, 11 and 12, MA, MHC with BA. This is BA is compulsory for both sections. Now, they were not BA, Lordship. Now I'll rely my Lordship judgment. The consequences of not having the B.Ed qualification at the time of appointment, and whether the subsequent first para, Lordship, will see here also the advertisement dated so and so, published in the newspaper Shillong Times, issued by the secretary so and so, inviting application for the post of assistant teacher arts at Rajabala Higher Secondary School, the date so and so, so and so. The qualification.
Any appeal against this order?
My Lord, review file, then just I think that the petitioner herein file appeal. Appeal is pending. Now, my Lord have referred so many judgment, Lordship. Paragraph 18.
Yes.
And prior to that, my Lord, if my Lord will refer para 16, my Lord has referred some judgment with similar issue, Lordship. That is also a violation of NCT norms. Then para 18, yet another authority referred to in this regard in the case of so-and-so. In this case, the Honorable Supreme Court has noted that the basic qualification for the post of assistant teacher, apart from educational qualification, was the training qualification of basic teacher certificate or Hindustani teacher certificate, of junior teacher certificate or certificate of teachers or equivalent training courses recognized by the government. It was held that, this is very important, Lordship, it is held that it is settled law that qualification should have been seen which the candidate possessed on the date of recruitment and not at a later stage unless rules to that regard permit it. The applicant could not have been appointed to the post of assistant without having the training required under Rule 8. That being the case, the appointment of the applicants were divorced the rules and could not be treated to be continued. Now para 27, Lordship. Apart from the NCT norm, there are several circulars issued by the government, Lordship.
Yes.
That B.Ed is compulsory, my Lord has held. It is submitted that apparently the officials of the schools involved have failed to note that there are already instructions issued by the authorities in the education department to say that for filling of the post of assistant teacher in a higher secondary school, the required or the essential qualification is B.Ed passed, which has been prescribed by the NCT, in absence of which no approval for appointment can be considered. In the case, this is, my Lord, that in that case the petitioner was not having B.Ed but subsequently obtained B.Ed, Lordship. My Lord has set aside. Now, para 33, Lordship. This is the instruction from the government. The letter dated so and so has conveyed the direction of the Director of Higher and Technical Education that all teachers at the school level should be graduate B.Ed. This following the NCT guidelines, which are mandatory in nature. However, the NCT guidelines, which are so and so as far as requirement of qualification and professional education for the level of higher secondary school is concerned, requires graduate with Bachelor of Education or its equivalent. This, according to the Learned Council, means that an educational qualification equivalent to B.Ed may also be MA. Since there is some ambiguity there, therefore the director has approved the appointment of the respondent numbers 9 with the condition so given, which is conformity with the NCT regulation, and as such there is nothing wrong in the appointment of the so and so. Now I am here referring 2001 regulation. I am referring 2014 regulation. Just now I have read out, Lordship, the NCT regulation that stipulated B.Ed is compulsory. My Lord, the paragraph 45, 46. My Lord, the petitioner has annexed a copy of Gazette of Notification dated so and so for recruitment of teachers in school so and so. In this regulation, the minimum qualification and professional qualification for appointment as a teachers in the school, high school level is graduate with B.Ed or its equivalent. It was this regulation which was referred by the Director of Higher and Technical Education Meghalaya in his communication dated so and so. Under the NCT Act, National Council for Teachers Education, established under Section 3A, is the only authority to prescribe minimum qualification for a person to be employed as a teacher in schools or in a recognized institution. Section 12A of the NCT Act provides that the National Council may by regulation determine the qualification of person being recruited as teachers in any primary, upper primary, secondary and senior secondary or intermediate schools or colleges by whatever name called, established or run. Now my Lord again referred paragraph 48, one judgment, Lordship. Thus, while referring to the advertisement dated so and so that place in so and so with the relevant provisions of the NCT regulation supra, the answer to the prescribed dilemma can be safely answered by referring to the case of so and so versus so and so, wherein at para 20 of the same, the Honorable Supreme Court has held as under. However, it is settled principle of service jurisprudence that in the event of a conflict between a statement in the advertisement and the service regulation, the latter shall prevail. In so and so court clarified the erroneous advertisement would not create a right in favor of the applicant on who act on such representation. In this case, Lordship, because in the advertisement B.Ed was not there, that is why they have taken a plea that they are qualified as per the advertisement. My Lord, referring the judgment, says that if the advertisement is against the rules, that will not validate the appointment. Here in the advertisement is contrary, Lordship. In the advertisement, although it was for a non-sanctioned post, but in the advertisement it shown that BA B.Ed, MA B.Ed, but the persons were appointed without B.Ed. That appointment is illegal. Another Supreme Court judgment, Lordship. Citation 2008 7 SCC 153. 153. First one. This is 2023 SCC online Meghalaya 296. 2023 SCC online Meghalaya 296. My Lord, para 18.
Yes.
Para 18. If the essential educational qualification for recruitment to a post is not satisfied, ordinarily the same cannot be condoned. Such an act cannot be ratified. An appointment which is contrary to the statutory rules would be void in law, and illegality cannot be regularized, particularly when the statute in no unmistakable terms says so. Only an irregularity can be, and the post so and so. Here also that because the lordship that NCT is a mandatory as a statutory regulation lordship, they cannot bypass that regulation. Lordship, para 30. They referred the judgment.
Yes.
Then it is settled law that the qualification should have seen
Para 30.
para 30, 30 lordship.
Okay, please.
Which the candidate possesses on the date of recruitment and not at a later stage, unless rules to that regard permit it. The minimum qualification prescribed under rule should be fulfilled on the day of recruitment. Equivalence of degree of so and so with that of BTC in the year so and so would not entail the benefit to the applicant on the day which they were appointed. The applicants could not have been appointed to the post of assistant without having training required under Rule 8. That being the case, the appointment of the appellant would divorce the rules and could not be treated to be continued. For the said reason, we did not find any substance and so on so. That is also with regard to the B.Ed lordship. Now, lordship, now what is their locus? What will happen if my lord find that my termination itself was illegal, and if my lord has passed the order for setting aside the termination order? What would be the consequences, lordship? My lord, I am referring judgment to 2016 to SCC 779.
(2016).
2016, lordship, yes.
Para.
I'll just, in order to get the brief fact of this case, lordship, I'll just refer para 13 first, lordship. Para 13.
13.
1-3, lordship.
Yes.
My lord, otherwise my lord will kindly see para 4 also, my relevant, para 4, lordship, para 4. Here a case, lordship,
Yes.
that allotment of PDS, that public distribution shop, lordship.
Yes.
Now the license was cancelled. Then after that, third party right was created. Now the original allotee, lordship, he has challenged the order of cancellation. Now subsequently, the subsequent allotee, lordship, he was impleaded. Now the court has set aside the authority has set aside the cancellation of the allotment. Now the subsequent allotee has challenged the cancellation. Now then the court has discussed about the locus of the subsequent allotee, lordship. Similarly, with my case, lordship, they are the subsequent appointee. I am the original appointee, lordship. The appellant authority, after hearing the appellant and the impleaded party, and upon perusal of the file, opined that the entire proceeding against the original LOT, that is me lordship, was initiated on the basis of the oral statement pertaining to the allegation made by some BPL card holders, and the shopkeeper had told them that their cards has been cancelled. There was no inquiry and investigation by the deputy district magistrate and the officials document as regard the cancellation of original ration card holder, that the LOT was not provided copy of the investigation report, and hence he was deprived of opportunity to submit his clarification. And on the whole, there were serious procedural lapses, and that on a careful scrutiny of a number of aspects, it was perceptible that the investigation carried out by the block development officer was absolutely faulty. Being in this view, the appellate authority by order dated allowed the appeal of the appellant, restored the allotment, and cancelled the allotment of the subsequent LOT. Being agreed by the aforesaid order, the appellant herein, who is the subsequent LOT, in respect of shop number so-and-so has preferred so-and-so before the High Court, by which the impugned order dated so-and-so relied upon an earlier judgment so-and-so was dismissed, and the writ petition on the ground that he has no right to continue the litigation being a subsequent LOT, for he has no independent right. Now, para 13, lordship.
Yes.
Though the narration of facts is a reflective of a different contour of controversy, that is the allotment and grant of license for a fair price shop, the seminal issue as noted herein above would hinge on the answer to the question pertaining to right to assail the order passed in appeal. The appellant was not impleaded as a party in the appeal, but she herself got impleaded. That is subsequent LOT, lordship. Assuming the appellate authority would have decided the appeal in favor of the original LOT in her absence, could the present appellant, a subsequent LOT in respect of the same shop, have been allowed in law to make a grievances by invoking the jurisdiction of any statutory forum, or for that the High Court under Article 227 of the Constitution? In essence, whether she is a necessary party to the litigation and entitled to contest the legal vulnerability of the order of cancellation, or in any manner advance the plea that her allotment would not be affected, despite the fact that the order of cancellation of the earlier LOT has been quashed. To appreciate the issue, we will dwell upon certain authorities, though they may pertain to different jurisprudence. Now, although this is a service lordship, the facts are similar to the facts which I have portrayed before the lordship. Here in this case, allotment given, subsequently the license was cancelled, then third party right was created, the original LOT challenged his cancellation, the appellate authority has set aside now the subsequent he impleaded, he tried to make an independent right. So now the relevant person, lordship, one example is given, lordship, with regard to the page para 48, lordship.
Yes.
Para 48. A few examples can be given so that the position can be easily appreciated. There are provisions in some legislations pertaining to Gram Panchayat or Gram Samiti, where on certain grounds the competent authority has been conferred the power to remove the elected sarpanch or the chairman as the case may be on certain counts. Against the order of the collector, an appeal lies and eventually either a revision or a writ lies to the High Court. After his removal, someone by way of indirect election from amongst the member of the Panchayat or the Panchayat Samiti is elected as the Sarpanch or the chairman. The removed Sarpanch assailed his order of removal as he agreed by the manner, method and the reasons for removal. In his eventual success, he has to hold the post of the Sarpanch if the tenure is there. The question thus arises whether the person who has been elected in the meantime from amongst the member of the Panchayat Samiti or Sabha is a necessary party. The answer has to be a categorical no. For he cannot oppose the order of removal assailed by the affected Sarpanch, nor he can defend his election because he has come into being because of a vacancy arises due to differentiation. Here also, Lordship, I am against the order of my termination. It is on my part to argue whether my termination order was legal or illegal. Now, this subsequent appointee, he cannot come and say that my termination was legal. Cannot. Because he has got nothing to do with my termination, with that order of termination. Now, in fact, as per the judgment, he says that subsequent appointee is not a necessary party. My lord, last para, Lordship, 53.
53.
53.
Yes. Please.
53, Lordship. We have referred to the said decision in Ramesh Sonso in extenso as there is emphasis on curtailment of legal right. The question to be posed is whether there is a curtailment of or extinction of a legal right of the appellant. The appellant was a subsequent LOT, Lordship. The writ petitioner before the High Court was trying to establish her right in an independent manner. That is, she has an independent legal right. It is extremely difficult to hold that she has an independent legal right. It was the first LOT, that is myself, Lordship, who could have continued in law if his license would have not been cancelled. He was entitled in law to prosecute his cause of action and restore his legal rights. Restoration of the legal rights is pivotal and the prime mover. The eclipse being over, he has to come back to the same position. His rights get revived, and that revival of the right cannot be denied by the third party. Now, Lordship, I'll refer two more judgment, Lordship.
On the same point.
My Lord, here says, Lordship, when the structure, when the foundation gone, the superstructure automatically falls. Here in this case, Lordship,
Yes.
in order to get the factual aspect, Lordship, 2002 4 SCC, page 16. I'll just start from para 4 so that my Lord will find the under what circumstance judgment was delivered, Lordship.
Yes.
On 2/2/1999, after considering all the applicants, the fourth respondent selected and appointed the appellant. The fourth respondent selected and appointed the appellant as EDMC, Palasol Branch Post Office. He joined the office on so-and-so and was working as such. While so, the respondent number 5 questioned the appointment of the appellant before the tribunal, stating that in spite of the being an SSC pass candidate, no preference was given to him. In the counter affidavit filed on behalf of the respondent number 1 to 4, it was averred that the appellant was selected on merit and he was senior in age. By order dated so-and-so, the tribunal set aside the appointment of the appellant by allowing OA number so-and-so. Agreed by the said order, the appellant filed writ petition number so-and-so, which was dismissed on so-and-so. Then he filed review petition challenging the correctness of the said order, but that was also dismissed on so-and-so. The said order are assailed in this appeal by leave petition.
Yes.
Lordship, para 8, Lordship.
Yes.
Mr. Ajoy Chaudhary, the learned counsel appearing for the respondent number 6, contended that the appellant was appointed on extraneous grounds of seniority in age, so his appointment was rightly quashed. The respondent number 5 possessed higher secondary certificate and had better qualifications, so after the order of the tribunal, he was appointed. Therefore, his appointment ought not to be disturbed in this appeal. He further submitted the so-and-so. Your Lordship, the appointment of the appellant was challenged by the respondent. Now the tribunal has quashed the appointment of the appellant. Now after the quashment of the appellant's appointment, Lordship, the respondent was appointed on the direction of the tribunal, Lordship.
Yes.
Now the appellant, he challenged his order of removal. Now matter ultimately went to Supreme Court. Now what is the observation my Lord will see? Page para 15, Lordship.
Yes.
Without properly examining the content of the counter affidavit, the High Court sustained the order of tribunal. In the light of the above discussion, we are of the view that the selection of the appellant was wrongly set aside. Now, in so far as the selection of respondent is concerned, that is a consequential action and it cannot stand, as the impugn order of setting aside the selection and the appointment of the appellant were held to be bad. Therefore, the selection of respondent number 5 automatically falls to the ground. The impugn order of the High Court maintaining the order of tribunal are set aside. The appellant shall be reinstated in service within 1 month from the date of the continued service. However, he will not be entitled to so and so. Here also, my Lord, briefly, if I submit, Lordship,
Yes.
appointment was quashed by the tribunal. Then, on the strength of the direction given by the tribunal, the respondent was appointed. Now, the petition appellant, he filed appeal, he challenged his order of removal. Then matter ultimately went to the Supreme Court. The court has upheld his, set aside his removal order, that it was illegal, he ought not to have been removed. Now, once the very order of his removal is set aside, Lordship, that means he will restore back to his original position. Then the subsequent appointee will have no any stand, Lordship. He will go automatically.
Yes. That has to be spelled out.
Pardon, Lordship?
That has to be indicated in the relevant orders, or
Pardon?
that has to be indicated in the order that, once the earlier petitioner is reinstated, then he.
My Lord, he says that he is a consequent. My Lord, paragraph is very clear, Lordship. My Lord, I'll just read out once again, Lordship. insofar as the selection of respondent is concerned, para third line, Lordship, fourth line, is concerned, that is a consequential action and it cannot stand as the in-pin order of setting aside the selection and the appointment of the appellant are held to be bad. Once the order by which he was removed was declared to be illegal and void, that means that nothing remains, Lordship. He will fall automatically, the subsequent LOT. Very clear, Lordship. That is why my Lord is very clear. Insofar as the selection of respondent is concerned, that is a consequential action because that has come after my removal. And it cannot stand, cannot. Once the in-pin order of setting aside the selection and the appointment of the appellant are held to be legal. My Lord, today if my Lord find that my termination order is illegal, that his appointment will go automatically because he came under different circumstances. It was a consequential action. Lordship, one more judgment, Lordship.
Yes.
2011 5 SCC, page 142. Page 142. Paragraph, Lordship,
Yes.
32 and 33.
Yes.
It is a second legal proposition that if the initial action is not consonant with law, subsequent proceedings would not sanctify the same. In such a fact situation, the legal maxims sub leto fundamento cedit opus is applicable, meaning thereby, in case a foundation is removed, the superstructure falls. Next para, Lordship. In Badrinath versus so-and-so, this court has observed that once the basis of a proceeding is gone, all consequential actions, orders would fall to the ground automatically, and this principle of consequential order, which is applicable to judicial and quasi-judicial proceedings, is equally applicable to administrative orders. Here same, Lordship, once my termination is declared to be void and null and void, then their appointment will go automatically. This is because they are consequential action. Lordship, in item number 1 and 2, I sum up, Lordship.
Yes.
Apart from the procedural irregularities in conducting the DP against the petitioner herein, Lordship, the very fact is that the section 9 of the Meghalaya Education Act was not followed. 9.2 says that before termination the approval has to be obtained. That has not been done, and this fact the government has categorically admitted in their counter affidavit. So on that ground, the termination would be illegal, Lordship. Now, so far as the other appointees is concerned, Lordship, leaving aside whether they have B.Ed or not, whether any advertisement was floated or not, whether their appointment was as per law or not, the very fact is that they are not the necessary party. Once my Lord restore me in my original place, their appointment will go automatically. Now, Lordship, I'll start
No, you have.
1 and 2 I have
finished.
done, Lordship.
So, should we get the response from the respondents on these two first?
But it is up to them, but because what I am saying, Lordship, because that so far as the replacement is concerned, Lordship, that judgment and that argument will cover the other item number 3, 4 and 5.
Okay.
That with regard to the replacement. In one case, one of the petitioner is B.Ed, Lordship.
Okay.
B.Ed. And the petitioner in item number 2, he has already retired, Lordship. So now, my Lord, once termination is set aside, that I am entitled to get my benefits.
Okay.
I have referred some judgment also which Supreme Court has held that given some benefits with back wages and all. So after that I will file a written short note, Lordship, each and every case, so that my Lord will
So it'll be clear. You know?
clear. Each and every case I'll make a. Now this is up to in the last date. My that senior that Shangreshu, he put some reservation that once my hearing is concluded, then they will start. I don't know whether today
Yes, you're there.
what I am saying, Lordship, because
Okay, then you continue with the other.
yes, Lordship.
So we will go to
Item number 3, Lordship. Here also factual aspect will be the same, Lordship.
What is the case here?
Here, Lordship, at the time of the petitioner in item number 2, he is an assistant lecturer, Lordship, in Assamese department.
Yes.
The documents.
This is also not a case. This is not a case of termination.
My Lord, it was a case of termination. Now Lordship will briefly recollect, Lordship, because 4 teachers, 2 were suspended on the same day and 2 were terminated on the same day. Then against the suspension as well as the termination, the petitioner herein, they file an appeal before the director. And so far as the suspension of the teachers were concerned, direction is given that you go, you follow the procedure. You cannot suspend like this. And so far as the termination is concerned, the director has set aside the order of termination, saying that no, you cannot terminate like this without giving ample opportunity to the other side. That has already been set aside, Lordship. Now here, after the termination order was set aside, now the managing committee did not allow me to work, because my Lord have seen that because they have already been replaced. Now where I'll go? This is with regard to salary and direction to allow me to work. I am referring the same documents, Lordship. My Lord will first see his appointment order, Lordship. Page 13. My Lord will, page 14 will be the approval order, Lordship. That will be better, Lordship. This is the approval order. Page 14. Page 14, serial number 2, Lordship.
There's a clear copy. You have not annexed a clear copy. What is the date? 29.
This is, Lordship, yes, Lordship.
20th September.
This is 2010-2005, Lordship.
10 or 9?
2010, Lordship. 29, Lordship. 9.
See, that's the reason I told you have not.
My Lord, that approval is given 2010, Lordship. That is why I am referring the approval order, Lordship.
Where's the approval order? This
Below
is
down, Lordship. Inspector of School, that memo number is given, Lordship.
Okay.
That is
approved. Yes.
Approved, yes, Lordship. My serial number is at 2, Lordship. These are the teachers, Lordship.
Okay.
Now here also first we This is a complaint of 2014.
Yes.
This is a similar complaint, Lordship, that a principal is not giving the salary in full.
Yes.
Then second, 2016, page 16, also another complaint we have given to the principal. The please, you have received the salary from the government, please pay us.
But this is for salary.
This is for salary, Lordship. Because termination has already been set aside, Lordship. Now I cannot challenge.
But you are not been allowed to?
No, no, Lordship. Yes, Lordship.
Then who is there in your place then?
Now, my Lord, the subsequent appointee.
Okay.
Because from item number 1 to 5, 5 teachers have replaced the 5 petitioner here. So because the appointment were made immediately after my suspension and the termination.
Okay. Where is the appointment of that subsequent?
Lordship, I'll come to that. First, I'll just Lordship will the order issued by the director, Lordship. First, that order by which the termination order was set aside. That is at page, Lordship. Page 41. I'll just see my order of termination first, Lordship. 41. Same set of allegation, Lordship.
Yes.
The date is very important, Lordship.
Same date?
Same date, Lordship.
Okay.
11/4.
Yes.
Now, Lordship will find the operative part of the director order, page 43.
Page 43.
Para 4, Lordship. Now, start from now, Lordship. The operative part, setting aside of the termination. Now, may I read, Lordship?
Yes, please.
Now, after examination observation of the documents relating to the termination of the 2 teachers, question arises whether the principal has followed due process of law which is justiciable. It may be mentioned that the principal has issued show cause notice. However, I am of the opinion that ample opportunity should have been provided to the teachers before resorting to direct termination from the service. It is important that that before direct termination of the service, teachers should have been placed under immediate suspension, pending disciplinary proceeding and inquiry, which is the practice procedure. And if the delinquent teachers are held guilty of any allegation of charge, the teachers should have been awarded with any other punishment and followed by termination from service thereafter. This not being followed in the process of action taken against the teachers. I therefore held that the direct termination issued by the principal is not justified and the point of law and is hereby set aside. And so far as the other teachers who were suspended on the same date, Lordship, that they have some proceeding was initiated, that Mokbul and other teachers, item number 1 and 2, Lordship. Item number 1 and 2. They are initially suspended, that subsequently terminated. But item number 3 and 4 terminated, and the termination was set aside by this common order, Lordship. Now, after the termination order, Lordship, when we challenged this order, Lordship, before this honorable court, now there were some pending salary
to be paid to the petitioners. Now 2019, February 2019, Lordship, they have, government has cleared the salary. The salary were directly paid to the account of the petitioners here in Lordship. Till February 2019, Lordship. Now Lordship will find their appointment. My lord, this is an affidavit of May 2025, Lordship. The affidavit of the respondent number 6. My lord has got it.
Yes.
Affidavit of respondent, that affidavit May 2025. That appointment is at page 16.
Just a minute.
Page number is the same, Lordship.
Yes.
Lordship, may I read the appointment order, Lordship?
Page.
Page 16, Annexure R1.
Yes.
Number so-and-so, dated so-and-so, dated Garudubi 20 April 2018, subject to termination without assigning any reason thereof. Sri Ariful Islam MA Assamese is hereby appointed as an assistant teacher in Assamese on annual contract basis for a period of so-and-so to so-and-so with salary 24,000 per month. Number so-and-so, dated Garudubi the 20 April 2018, subject to termination assigning any reasons thereof. Mokibur Rahman MA English B.Ed is hereby appointed as an assistant teacher in English on annual contract basis. This is the teacher, Lordship, who has replaced in the petition item number 4, Lordship, that Mokibur Rahman. And that Ariful, that first, because in this appointment 2 appointments were made, Lordship, common order. So the appointee number 1 is the person who has replaced the petitioner in item number 3.
Okay.
And the appointee number 2 is the person who has replaced the petitioner in item number 4, Lordship.
Okay.
The service may be removed and renewed subject to satisfaction of performance of their sons and maintaining discipline in the school. They are directed to join in their respective post as soon, provided that this issue has an approval of the competent authority. MC resolution number dated 11/4/2018 with number. And 11/4/2018, Lordship, I have been terminated. And on the very day, they were appointed, Lordship. Again, there will be another appointment. This was a temporary appointment, Lordship. The next page is the another appointment, Lordship, for the same person. Now they have shown one advertisement, same advertisement, Lordship, because these are all predetermined. That advertisement were floated prior to the dismissal or the termination of the teachers. Page 20 is the same advertisement, Lordship.
With this page 17 and 18 the same.
Same, because earlier it was a temporary, Lordship, for a periodical appointment.
Okay. But here so converted. Okay.
Same date, Lordship, yes. 18 and this is 19. Year of appointment is 19. The date and month is same, Lordship. Because the managing committee has done systematically.
But on this next year.
Next year, Lordship. Because that appointment is only for 1 year, Lordship.
1 year. So he was appointed on regular basis.
Yes.
Again, permanent.
Yes, Lordship. Now, Lordship will see the advertisement, same advertisement, Lordship, at page 20.
Yes.
This is the same advertisement, common advertisement for all.
21st March.
Yes, Lordship. The advertisement for non-sanction, subsequently they were accommodative sanction.
Yes.
Now,
So you see, as per this advertisement, they have applied, they have gone through the selection process, and then their appointment was made regular.
subsequently made regular. Initially it was just
Initial
non-sanction, yes, because there is a condition that these people will need not to appear for the regular selection process.
Okay.
There is a condition, Lordship, in the appointment as well as in the advertisement, Lordship.
Okay.
I have pointed out, my Lord will see in the advertisement, Lordship. Paragraph 6.
Where is paragraph 6?
Down, Lordship, in the advertisement, Lordship.
Page
Page
17.
20.
Page 20.
This is a common
Okay, you pointed out that. No?
yes, Lordship. Yes, Lordship. This is now some declaration of result was shown, Lordship, on 28. That is also for non-sanctioned post. Now, here also, Lordship, the same judgment will apply. The person concerned is not BA.
Okay.
Now, next item also, my Lord, the page number, the document will be the same, Lordship. Here, in this case, the next item, Lordship.
Next item is
471.
471.
1. That appointment order, the approval order is same. The termination order also same. The setting aside of the termination is also same. The appointment order also same.
Yes. Same facts and circumstances.
Same facts, Lordship. So I am not going back, Lordship, under what circumstance I have been terminated, Lordship.
Yes.
Because, my Lord, that issue has already been set aside, Lordship. I am not required to go under what circumstance I have been terminated.
Since your termination was set aside by the director.
So
now
and
here so in 471 is only issue of area pay.
area pay. 470 and 471, Lordship, yes. And both the teachers working in higher secondary section.
Okay.
The 470, the item number, the petitioner item number 3 is Assamese lecturer, and the petitioner item number 4 is English lecturer.
Okay.
And only difference, Lordship,
Yes.
the person who has been replaced, the petitioner in item number 4, that is in writ petition 471, he was having B.Ed. Leaving aside B.Ed, Lordship, in view of the judgment, Lordship, they are not the necessary party, Lordship. So once my Lord has found that yes, rightly or wrongly, the termination order has already been set aside by the competent authority, Lordship, that means I am in service. Now they are not allowing me to join in the service.
Okay.
Now, with regard to the pay, Lordship, I'll rely on judgment, Lordship. Now, what happened? Now, authority has set aside the termination, and despite the setting aside of the termination, the government or the school managing committee is not allowing me to join or did not revoke my termination order in pursuance of the director order, whether I am entitled for the salary for the period or not. I'll rely one judgment, Lordship. Citation 2024 SCC online, Supreme Court 2449.
Para.
My lord, the relevant para will be, I'll refer few para, Lordship. Relevant para will be 19, 21 and 22.
19.
19, 21 and 22.
Yes.
My lord, before that, I'll just read out the brief facts so that my lord, under what circumstances the court has made the observation in those 2-3 paragraph, Lordship. Here, Lordship, one lady judicial and 2 judicial officers were terminated, Lordship, by the High Court, Lordship. Now, the court has set aside the termination order. Despite there is a setting aside of the termination order, the High Court or the state government did not revoke the termination or did not allow the petitioner into service. Then the matter ultimately went to the Supreme Court, and the Supreme Court has given a direction to revoke the termination, and subsequently it was termination was revoked. Again, another termination was issued, Lordship. Now the Supreme Court has given a direction to release the salary from the date of termination till the date where the termination order was set aside. And so far as the new termination is concerned, the court says that this is a new cause of action, you have to challenge the new termination order. Your Lordship, I'll just from para 2.10, Lordship. Page number 4, 2.10.
Yes.
That on 24/2022, when the matter came up before the court, after hearing the learned senior counsel for the parties, this court granted leave and allowed the appeal after setting aside the impugned judgment of the High Court dated so and so. and the termination order dated, this is very important, 17/12/2019. It further requested the full court of the High Court to reconsider the matter, the order dated so and so as reproduced herein below. The termination of 2009 was set aside by the High Court, by the Supreme Court, by order dated so and so, Lordship. Now, para 2.11, Lordship.
Yes.
No consequential order were passed by the state after the order dated so and so, whereby the termination order of the appellant dated passed by the state government was set aside.
Yes.
Here also, Lordship, the order of termination has already been set aside by the director, but there is no consequential order, either from the subordinate authority or from the managing committee. Now, next page, para 2.12, Lordship.
Yes.
As the matter was further delayed and no decision was being taken, and the appellant had not been taken back in service despite the termination order being set aside, the appellant filed MA number so and so, which was disposed of by the order dated so and so, requesting the full court of the High Court to decide the matter within 3 months. It was thereafter that the full court of the High Court in its meeting dated so and so resolved to reiterate its earlier decision dated so and so, terminating the services of the appellant. Again he was terminated.
Yes.
Now para 2.15.
Yes.
During the pendency of the miscellaneous, because that was only on miscellaneous application, that is why the Supreme Court did not interfere the subsequent termination order, Lordship.
Yes.
During the pendency of the said MA, and when the state of Punjab was also called upon to serve the copy of the MA by order dated so and so, and with the matter being listed on several occasions, the state of Punjab passed an order dated so and so, terminating the services of the appellant with retrospective effect. That is again with effect from 17/12/2009. That order has already been set aside. The said order dated so and so has been filed along with so and so. It is on the above sets of fact we have heard so and so, so and so. This is the submission, Lordship. Now the operative part, Lordship. Para 19. Having considered the submission advance at the outside, we make it clear that we are not entering into the merits of the matter. That is the reconsideration by the High Court in the full meeting held on so and so, and the termination letter issued by the state on so and so. That is the subsequent termination, Lordship.
Yes.
The order could be treated, this order could be tested before the High Court by way of a fresh writ petition to be filed by the appellant, and such liberty having been granted by this court in the writ petition under Article 32 of the Constitution of India filed by the appellant, which was withdrawn on so and so. For the above reason, the case relied upon by Gupta was not dealing with the case laws relied upon by so and so. Now, 21 is very important, Lordship. Once the termination order is set aside and the judgment of the High Court dismissed the writ petition challenging the said termination order has also been set aside, the natural consequences is that the employee should be taken back in service and thereafter proceeded with as per the direction. Once the termination order is set aside, that the employee is deemed to be in service, we find no hesitation, a justification in the inaction of the High Court and also the state in not taking back the appellant into service after the order dated 20 April 2022, by which the order of termination was set aside, Lordship. No decision was taken either by the High Court or by the state of taking back the appellant into service, and no decision was made regarding the back wages from the date the termination order had been passed till the date of reinstatement, which should be made on the date of the judgment of this court. In any case, the appellant was entitled to salary from the date of judgment dated so and so, 20 April 2022, till fresh termination order was passed on so and so. The appellant would thus be entitled to full salary from the above period to be calculated with all benefits admissible, treating the appellant to be continuous in service. Insofar as the period from so-and-so after the termination order dated so-and-so was passed till so-and-so, the period judgment of the court, we are of the view that end of justice would be served by directing that the appellant would be entitled to 50% of the back wages, treating him to be in service. Now, the sum and substance of this judgment is, Lordship, once the termination order is set aside and there is no order from the authorities allowing them or taking the person back into service, that means he is in service, and in that eventuality he is entitled for salary for the period when he was terminated till the date of set aside. And here in this case I am entitled till date, Lordship, till date. So this judgment I am relying with regard to item number 3 and 4, Lordship. My Lord, so far as item number 1, 2, 3 and 4, I have concluded my submission, Lordship. There are 3 or 4 issues, pertinent issues, Lordship, in all these cases, Lordship.
Yes. Where is my note?
So item number 5, 6 and 7. 5 is slightly different and 6 and 7 no replacement, Lordship. So 5, Lordship, on the next day, because this case, what happened? In this case, Lordship, the allegation, item number, I am talking about item number 5, Lordship, that he has forged the document. And without inquiry, without anything, he has been terminated. And case has been lost, my Lord. Now, that case is slightly different, Lordship, from this. So I, on the next Friday, Lordship, because Friday is having, my Lord is not having the division bench, so I feel comfortable on Friday. So the other matter I'll conclude on the next date, Lordship.
Okay.
And after that, I'll file my written submission, written note, Lordship.
So the respondents will wait till he complete with all the
Lordship,
matters?
I'm appealing for item number 3 to 7, Your Lordship. Let him finish, then I'll make a common argument, Your Lordship.
Okay. Heard Mr. S. A. Sheikh, Learned Counsel for the petitioner, who has continued with the argument in this case, but has stop. But has made a prayer that he may be allowed to continue with the hearing on the next date fix.
My Lord, on the next day, I'll start item number 5, Lordship.
Okay, doesn't matter.
Yes.
As prayed for, this is matter for the hearing on 2021.
Next Friday, Lordship.
Next Friday.
Yes,
Item number 9.
Yes.
Lordship, praying for some time today, Lordship. Dr. Muzika is not available today. Has some personal difficulty, Your Lordship.
No, but this has gone for mediation.
My Lord.
Your Lordship, it could not be settled in
Could not be
mediation.
settled.
Any report?
No, Your Lordship.
Okay, well, that's it. On prayer made by Mr. Learned Counsel for the respondent seeking accommodation on the ground of personal difficulty of the learned DSGI. Matter is adjourned. This is him after 1 week. 1 week?
Much obliged.
Item number 11.
May I please, Your Lordship?
My lord, it appears that the counsel for the petitioner is S. Bhattacharjee, my lord. My lord, she is under medical treatment, my lord. She had a stroke the other day. So she is admitted in Negrims, my lord. So I'm just, though I'm not the counsel on record, so my lord, I'm just informing the court.
On account of the illness of the learned conducting counsel for the learned counsel for the petitioner, for which mention has been made before this court, matter is adjourned. Please see him after 3 weeks.
My lord.
Item number 12.
After week.
Obligement.
Go to 16 more.
16.
Lordship, item number 17, that is criminal appeal. If this matter can.
Yes, Mr. Yubin.
No, Mr. Yubin is not there.
Item number 14 and 15.
I know he is
Oh, yes.
referring to item 17.
17th. Yes, my lord. In 17, my lord, the paper book is not complete, my lord. So 164 statement is not there. I've compared, and it's also there's additional charge sheet was filed, my lord, and that also is not there. So I'll need some time to compare, and if to file a additional paper book in this, my lord.
And after 2 weeks, your lordship. I come after 2 weeks then.
Okay, then how long? 2.
My lord, it is a legal aid matter,
Yeah,
so I'll just compare first. And
After 2 weeks, then your
2 weeks,
lordship.
2 weeks, my
2
lord.
weeks, your lordship. Yes.
So on 17 on preliminary by the parties, this is matter of 2 weeks.
Apply, your lordship.
Yes, Mr. Guru. 14,
My
15.
lord, item number 14 and 15, my lord. If it can come up in the next week, my lord.
Next week.
Joint request, yes.
Well, this is I have completed my part. That
It's-
is that
it's-
Molonghat
Oh,
matter.
that.
Yes, yes. So but if time does not permit today, my lord, I think next week, my lord.
Next week, Ini hadir ni kata.
Twenty-six.
26. 26
26th, my lord. 26th.
on preliminary by the parties. This is matter for the hearing on 26.
26th, my lord.
Deeply.
All right.